It's a real pleasure, it's an honor, it's a treat for me to be able to be on this particular panel with two very distinguished scholars from whom I've learned a great deal and continue to, two longtime colleagues and collaborators, and more importantly, two very dear friends of mine. This is just a special time. I don't believe that there are many people working in the legal academy on these issues of speech and religion who have more insight and eloquence than our two panelists today. So we're going to hear, this being Notre Dame, we follow the natural law, which means we'll go alphabetically. We'll hear first from Professor Mark DiGirolamo, who is a professor of law and the associate director of the Center for Law and Religion at St. John's. He writes and teaches about criminal law, law and religion, the First Amendment generally, and also constitutional law. His book called The Tragedy of Religious Freedom was published by Harvard University Press about 5 years ago, and it's outstanding. Michael Moreland is the university professor of law and religion and the director of the new-ish Eleanor McCullen Center for Law, Religion, and Policy at Villanova. He shares many of Mark's teaching and research interests, and he writes on law and religion. He's also trained in theology, writes on theological ethics and constitutional law more generally. He was a fellow here at the Center for Ethics and Culture a couple years ago. He's a graduate of Notre Dame. And one thing that unites both of our guests is they were both relatively recently liberated from one of the most crushing and dreary jobs there is, that is being an associate dean. And having been there myself, I just can tell you what how fun it is to have that weight lifted. So without further ado, we'll start with Professor DiGirolamo.
Well, thanks very much, Rick. Rick is one of my oldest and dearest friends in the Legal Academy. It's always a pleasure for me and actually spiritually reinvigorating for me to come to Notre Dame. I try to make a point of doing it at least once a year as a kind of personal pilgrimage, and it's always well worth it. So in these remarks, I will focus on an interesting rhetorical development in two of the most recent free speech cases in the last U.S. Supreme Court term. And then I'll offer some thoughts about what this rhetorical development might suggest about the condition of the First Amendment today, and specifically about the relationship between the speech clause and the religion clauses. There's something greater about the First Amendment that can be learned by this seemingly small detail of rhetoric. So it's a kind of an exercise in magnum in parvo, right? Big and small. Something big can be learned from something small. And the thrust of my comments will be that over time, the justifications for and limits on the right of free speech and religious freedom tend to move together, move in unison, rather than separately or distinctly. That observation, if it's right, might have important implications for how we understand the place and role of the First Amendment in our democracy at any given moment in our democracy's history, including the present and the future. But first, the parvo, the rhetorical development. In two cases this past term, 4 dissenting justices, adopted the metaphor of weaponization to describe the use of the right of free speech to resist certain kind of government action. So let me describe those cases briefly, just so that you have them clearly in mind. So the first is National Institute of Family Life Advocates versus Becerra. So here the court reviewed a challenge to California regulations imposed on pro-life pregnancy resource centers. One of these regulations required state licensed centers to advertise the availability of state-subsidized abortion, while a second required unlicensed centers to notify women prominently and in several languages that those centers were not licensed. The law manifested an intent to target, quote-unquote, largely Christian belief-based centers, which California state legislatures believed were not sufficiently, quote-unquote, forward-thinking about abortion. And this is recorded, actually, in the statute's legislative history. The quotes are from the statute's legislative history. In an opinion 5-4, Justice Thomas, Clarence Thomas, held that the statute violated the freedom of speech. Its provisions compelled these centers to express content-specific messages, including messages about obtaining the very service to which the centers objected, which was abortion. And the court relied on the difference between speech and conduct in distinguishing cases like Planned Parenthood versus Casey, in which abortion providers could be required, in which the court held that abortion providers could be required by the state over their own free speech objections to obtain informed consent before performing an abortion. So Thomas said, look, those cases don't apply because the pro-life centers in Becerra, in this year's or this past year's case, were not performing abortions. California had selectively exempted general practice medical facilities from the same requirements that it imposed on the pro-life centers, suggesting that the state of California had an illegitimate interest in compelling exactly these centers to advertise state-sponsored abortion. There was a dissent. Justice Breyer dissented, joined by Justices Kagan, Ginsburg, and Sotomayor. And he said, the primary point that he made was that, look, if a state may require an abortion provider to tell a woman seeking an abortion about adoption services, which is part of what the court had held in this earlier decision, the Casey decision, then it should also be required, should also be able to require pro-life centers to tell a woman about the availability of state-subsidized abortion. So there's sort of a parallelism that Breyer argued for in his dissent, but he went further, arguing that the majority had empowered these pro-life centers, quote, to use the Constitution as a weapon, close quote, to defeat, quote, reasonable economic and social laws, close quote. So that's case number one. The second case is called Janus versus American Federation of State, County, and Municipal Employees, in which the court struck down an Illinois law that compelled non-members to pay public sector union fees. And in an opinion for the court, authored by Justice Alito on behalf of the same five-justice majority as in NIFLA, as in the first case that I described, the court held that these compulsory union fees violated the freedom of speech because they forced support in the form of financial subsidies for messages with which the litigants disagreed. As in Justice Breyer's dissent in the NIFLA case, Justice Kagan's Janus dissent accused the majority of, quote unquote, weaponizing the freedom of speech. Kagan denounced the justices in the majority as, quote, black-robed rulers overruling citizen choices, close quote, and censured the majority for, quote, turning the First Amendment into a sword, close quote, with which to smite down democracy. Quote, the First Amendment was meant for better things. It was meant not to undermine, but to protect democratic governance, close quote. That's from Justice Kagan's dissent. Incidentally, black-robed as a term of abuse was first used by Justice Scalia in his dissent in United States versus Windsor to describe the court's arrogation to itself of the power to strike down what was then the Defense of Marriage Act. This was a decision actually that Justice Kagan joined, on the basis that the statute restricting marriage for federal purposes to two members of the opposite sex ran afoul of the court's substantive due process sexual liberties jurisprudence. And look, Justice Kagan almost certainly intentionally was echoing Justice Scalia, though I think it seems plain that her views of sound and unsound social policies and of the circumstances in which the court legitimately overturns democratic choices are different than Justice Scalia's. But it's striking that both of these cases, Nifla and Janus, also very much reflect the expansive view of the First Amendment that really came into its own in the 20th century. If this conception of free speech is today, as the dissenters charge, if it's serving conservative ends, one should recall that for many decades it has promoted progressive ends in the court's cases involving defamation, obscenity, sexually explicit speech, and other great expansions of free speech in the early to mid to late 20th century. So that's the rhetorical development, the use of the word weaponization. What does it mean? What does it mean? Whatever it means, in my view, should be connected to similar developments in the law and rhetoric of religious freedom. In fact, the weaponization metaphor, in its most recent incarnation at least, was minted about 5 years ago to attack religious freedom when the Hobby Lobby case evoked so much outrage. At that time, it was not adopted in the Supreme Court, but it was quite common to see it in popular press accounts as well as in academic commentary. Religious freedom, it was said, was being weaponized to do violence to more important interests in sexual autonomy and the more important concerns of other third parties. The rhetoric of weaponization is effective, I think, because it recharacterizes certain kinds of exercises of liberty, whether of speech liberty or religious liberty, as acts of violence. Acts of violence, of course, are never constitutionally protected. And it was and remains a technique, in my view, again, an effective technique, of those using the imagery of weaponry and violence to scare quote religious freedom as well as free speech and to set those rights against quote unquote civil rights. The tacit assumption being that religious freedom and free speech are not also civil rights, but instead stand opposed to them. Some prominent academic advocates of free speech constriction, most recently, have even used the metaphor of First Amendment weaponry aggressively in advocating for nakedly partisan uses of free speech. But until the 2017 Supreme Court term, the metaphor had not appeared in any Supreme Court opinion. And it was interesting to see it appear there not once, but in two separate opinions joined by 4 justices apiece. Interesting development, but not, in my view, an unexpected development. The resistance to speech and religious freedom rights that we are now seeing is in large part the result of 2 interrelated 20th century developments. The first is, and the more important, is their systematic disconnection from any overarching idea of the public, political, and moral good, from any conception that transcends the self. Freedom of speech in this period was increasingly justified as enhancing and maximizing individual autonomy. Other earlier justifications and limits of free speech gradually but steadily receded in prominence, and by the late 20th century, these justifications and limits had largely supplanted, or I should say had been supplanted. These justifications had been subsumed by the view that free speech is intrinsically valuable for human identity and for self-actualization. That self-regarding rationale for free speech was united during this period with a related prudential consideration that ostensibly repudiated any state or official orthodoxy as to the value of speech. So the new rule was the government must never make judgments about the substantive worth of speech, and courts must assiduously guard against communal efforts to set content-based limits on the full freedom of speech. In the rhetoric of American law and culture, free speech was in this period routinely defended as inherently good, as an inherent good for the individual and an inherent American social good. In fact, defined in terms of what it means to be American. Some limits remained and do remain, but communal political judgments about the value of the content of speech were never thought any longer legitimate grounds for legal restriction. Quote unquote, anti-orthodoxy of all kinds became a kind of watchword of free speech protection. Government can never be granted the power to judge speech's value for both principled and prudential reasons. But once the right of free speech was understood as a self-regarding and intrinsic end of human fulfillment, then there was very little to inform its exercise beyond the caprice of the exerciser. And in this period, the prevailing legal conception of the right of free speech was united with that of the right of freedom of religion as well. Solipsistic, personalized, changeable, deracinated from any common purposes and traditions, and often completely unchallengeable, inasmuch as there are no acceptable extrinsic criteria for doing so, certainly none with which the political community could be trusted. So that's development number one. Second development, related to the first, is the enormous expansion of these rights during this period. The last 100 years, as one book reports, recent book reports, was, quote, the free speech century. And the right of religious freedom has also enjoyed tremendous growth, tremendous expansion. Now, the expansion of the First Amendment, in combination with its steady disconnection from any common ends or purposes, has in more recent years produced an extremely powerful reaction. It has resulted in, and here I'm just being descriptive, we can talk, whether this is a good or bad, just as a descriptive matter, it has resulted in great dissatisfaction and great anxiety in many quarters about the First Amendment. It has generated an avalanche of arguments for constriction of the First Amendment. In the paper from which this talk is drawn, I have a section called First Amendment Constrictors, with like a little snake coming along next to it. But it's a huge, huge new development, the constrictors. Those advocating for First Amendment constriction today argue that new values derived from new rights and interests in dignity, equality, democracy, third-party harm, and others have to be set against and balanced against the freedoms of speech and religion. Many of these values and interests were generated and entrenched just at the moment where you had a kind of hypertrophic, expansionist First Amendment. Even Justice Oliver Wendell Holmes Jr., who's hardly a moral realist, spoke in his famous Abrams dissent about the quote-unquote point of the First Amendment as the quote, pursuit of the truth as an ultimate good, close quote. And for the new constrictors of the First Amendment, these other rights and interests serve to reorient the First Amendment, to reunite the freedom of speech and religion with, as Justice Kagan put it in her Janus dissent, the quote-unquote better things, the higher purposes, right, to steal a line from this conference, the higher purposes, or as Holmes put it, the quote, ultimate good, close quote, of American political and moral life. Now, at present, it's less than clear whether arguments for First Amendment constriction will ultimately prove successful in constitutional law. Maybe in tandem with a weaponization metaphor, they will be adopted at some point by a majority of the court, though to date they have only persuaded at most, as I mentioned, a quorum of dissenters. Given the deeply fractured state of American political life, and in the wake of the political wreckage that has followed the massive expansion of the rights of free speech and religious liberty, one might think that imposing new limits on First Amendment rights in the name of dignity or democracy or equality or sexual freedom or third-party harm or any of the other purposes championed by the new constrictors is far likelier to exacerbate social and civic fragmentation than to reconstitute it. On the other hand, maybe any course of action at this point, whether constriction or continued expansion of First Amendment rights, is likelier to result in further fracture than greater civic unity. But whatever happens, the point I want to conclude on is that the rights of free speech and religious liberty are likely to suffer similar fates. In some work in progress, I've tried to show that how at each of the principal periods of their respective development, in the early republic, during the 20th century expansion, and today, the justifications for and limitations on these two rights have proceeded together. They have proceeded in tandem. In fact, it's remarkable that these rights, during all of these great important historical periods and shifts, have basically proceeded side by side. Several scholars see things differently, and I should mention this. They argue that various American cultural and sociological developments, including, for example, the declining religiosity of Americans, at least as respects traditional religions, and the sense that religious liberty has been captured by specific ideological constituencies, they argue, look, these are going to weaken religious freedom as a right in ways that is unlikely to affect freedom of speech, right? And they're probably right that most people in the United States today, at least as an abstract matter, are more broadly sympathetic to speech rights than they are to religious freedom rights. But in my view, there are reasons that one should be skeptical about the claim that the right of free speech is more powerful today than the right of religious freedom. The first has to do with the size and role of the government. In a society in which the government takes on an increasingly large place and role in the life of the citizenry, the protection of rights tends to become a zero-sum game. Every inch gained for individual rights, like that of religious freedom, is an inch lost for the state. That dynamic should in time affect all rights, including the freedom of speech, because the key issue is not evolving cultural or social perceptions of any given right's strength, but evolving cultural perceptions of the strength and proper ambit of the state's power. But there's a second reason for skepticism about the view that the strength of free speech rights and rights of religious freedom is greatly imbalanced in favor of free speech. And that's this, and I'll conclude with this. The fundamental frameworks within which these rights are situated, the shared assumptions that have influenced views about these rights as their justifications and their limits, those run together across the history of their development. The early republic, for example, was informed by a natural rights framework. The 20th century by modernism and liberalism. And today, maybe a new structural and theoretical framework is emerging in the claims of the First Amendment constrictors. Rights of free speech, rights of religious freedom, they are invoked by the discontents in these regimes, those who reject or at least stand to one side of the dominant cultural orthodoxies and frameworks. And those who embrace the dominant orthodoxies and frameworks of any given era are likely to oppose, and to oppose vigorously, claims of First Amendment right that obstruct or impede the progress and the entrenchment of those frameworks. The migration of the weaponization accusation from religious freedom to free speech over only a short span of years suggests that the right of religious freedom and free speech, just as in past eras, is likely to be conjoined. Thank you very much.
Well, thank you to the Center for Ethics and Culture, as always, and to Carter and his staff. And thanks also to my friend Rick Garnett for moderating. And I'm delighted to be on a panel with my friend Mark DeGirolami, and I'm glad to all of you for coming and resisting the urge to listen to Adrian Vermeule upstairs. And I have to say that Mark and I didn't coordinate much. I mean, we talked a little bit on email, but our talks have a lot of similarity, including discussing some of the same cases. So maybe we should just mush all this together and get a co-authored book out of it. But the title of my talk is The State and Freedom of Speech. But the alternative title is How I Learned to Stop Worrying and Love the Supreme Court's Doctrine on Freedom of Speech. My thoughts on this topic began with a debate this past summer that was over a case Mark mentioned, which is a case Janus versus AFSCME, which was about the constitutionality of public sector union agency fees. As some of you may know, this was a case, and there have been other cases that had raised this question over the last few years about whether or not the government could require as a condition of your being a public employee that even if you object to joining a public sector union, that the state could nonetheless require that you pay a so-called agency fee to offset the costs of the benefits of collective bargaining. And my friend Rick Garnett and I, on our blog Mirror of Justice and some other forums, were engaged in a bit of a debate. Didn't rise to the level of national attention maybe much, but a bit of a debate with some other Catholics about whether or not it was inconsistent to hold, as we did, that there were genuine First Amendment free speech concerns raised by these public sector agency fees cases. And the view of many progressive Catholics that the Church's longstanding, certainly post Rerum Novarum, favor of unionization generally militated in favor of doing what was necessary to build up unions, including public sector unions, and that these First Amendment arguments were sort of laughable. And so that caused me to start puzzling about, well, is there a Catholic way of thinking about freedom of speech? Because what it seemed to me was that there was, on the one hand, this kind of Catholic argument that the Church favors unionization, and so these public sector union agency fee cases should be decided in favor of the unions. And on the other side, there didn't seem to be much of a concern, or a well-developed concern, certainly, in favor of saying that there was something to an idea of Catholic freedom of speech. And to be sure, you can look through the papal social encyclicals. There's one reference to freedom of speech in Pacem in Terris in 1963. You can kind of pull out some strands of the Council's Declaration on Religious Freedom, Dignitatis Humanae, and mount something of a defense of freedom of speech out of that. But there just isn't much either in the magisterial social teaching of the Church or in commentary about it. So just take a step back here and survey the current law of the land, which Mark DeGirolami already has done a very fine job of detailing. So from one perspective, we're living amid a golden age of free speech law, certainly in the decisions of the U.S. Supreme Court, with very, very few exceptions. Free speech claims prevail across the board. As mentioned already, just last term, the court held that public sector union agency fees were unconstitutional, compelled disclosures by nonprofit crisis pregnancy centers in Niffle versus Becerra, which Mark mentioned. A Minnesota law restricting political apparel at polling places was held to be unconstitutional. And of course, in a closely watched case the court held in Masterpiece Cake Shop, that a baker who declined to make a cake for a same-sex wedding celebration had been subject to anti-religious bias by the State Civil Rights Commission, which avoided resolving the free speech issues, but with some members of the court clearly signaling that they thought the free speech issues cut decisively in favor of the baker. And so also over the last several years, we've seen protesters at military funerals, producers of videos depicting animal cruelty, a band that adopted an ethnically disparaging trademark for their name, vendors of violent video games, a pro-life sidewalk counselor in front of an abortion clinic, for whom my Senator Villanova is actually named, Eleanor McCullen, all prevailed in free speech challenges to government restrictions, often in unanimous or nearly unanimous decisions by the court. More controversial, of course, has been a series of cases striking down restrictions posed by campaign finance regulations, Citizens United most prominently. But here, too, the free speech claims have prevailed, albeit usually more narrowly, 5-4. And so in some ways, free speech has never been more secure and confident. But we also seem to be living amid an age of anxiety about freedom of speech. One iteration of Mark's paper, I think, was sickness unto death, right? So there's a kind of Kierkegaardian theme to this. When sometime around 2012, I first started teaching Villanova's required Con Law 2 class that includes a large component of free speech law, it was sometimes hard to get students to take the government's position in these speech cases. Now, some of that might have been just a general reluctance to buck the tide of the court's decision, but it also seemed to reflect an ambient libertarianism and cavalier dismissal of concerns about, say, the effects of violent video games, which is a case in which the court had, I mentioned, struck down a California restriction on the sale of violent video games. Now it seems, though, as though the tide ever so slightly in the past few years has turned, as Mark mentioned, a bit against free speech. A Gallup survey earlier this year showed that 2/3 of college students do not believe that the Constitution should protect against hate speech. Half of college students support campus speech codes. Progressives, who were, of course, the great defenders of expansive protections for freedom of speech in such landmark cases as New York Times versus Sullivan, now decry the weaponization of speech and are making an argument that the First Amendment should be interpreted against some norms of egalitarianism that would open up a range of permissible restrictions on speech. And of course, there's a continued critique, or I should say a defense of a wide range of purported economic and safety regulation through speech, and also, of course, campaign finance regulation. What's a bit less well known is that conservatives have been free speech skeptics all along, in some ways. Forgotten is the importance of free speech to the fight over the Supreme Court nomination of Robert Bork in 1987, in which Bork was criticized for a law review article he had written arguing that essentially only political speech should be protected by the First Amendment. And in a series of writings starting in the late 1950s, Walter Burns argued that the Supreme Court's free speech jurisprudence had gone off the rails, forsaking the cultivation of civic virtue for license. And more recently, Hadley Arcus has argued that modern free speech jurisprudence is in the grips of moral relativism, as it puts, as he says, a facade of moderation for a radical interior, detaching speech from moral judgment. So this paper is born of my sympathy with the current free speech doctrine of the Supreme Court, while also worrying that it rests on an uncertain foundation. Part of the problem is the seeming inadequacy, or at least underdetermination, of the leading theories of free speech. The marketplace of ideas, there's actually a conference next door going on about that right now, democratic self-government, or expressive autonomy. So there's this ongoing effort to kind of reduce all of free speech law, or at least explain and justify all of free speech law, to these theories of individual expressivism, or the marketplace of ideas, or something about democratic self-government. But it always seems to come up short, that the cases can't all be reconciled under a coherent doctrine, and that the theories can't account for all of them. So my suggestion here is that the Catholic tradition, or at least some limited strands of it, might help us think through at least some aspects of free speech doctrine. Now, of course, I can't do justice in 25 minutes or so to the whole range of free speech cases, but I do want to take one slice of it, and that is to say the move over the past several decades to resolving a range of cases based on categorical determinations that a regulation of speech is based on its content or subject matter, and so is presumptively unconstitutional. This is, and Mark mentioned this a bit already, this is really kind of one of the hallmarks of the last few decades of free speech jurisprudence, is that the court moved from a lot of kind of balancing tests. I put it in a blog post this summer. We came from the disco era of free speech in the 1970s, where you'd have a lot of cases where there's a discussion of competing policy interests. There would be a lot of discussion of effects and consequences likely from a decision one way or the other. And that was the kind of, very much the kind of tenor of, and a lot of kind of one case at a time decision-making in the Supreme Court's free speech jurisprudence. A move from that approach to an approach now that's much more categorical. Formalistic is sometimes the pejorative word, not in my eyes, but sometimes the pejorative word that is thrown around, that instead you kind of put a free speech case into a category of analysis, and then you sort of deduce an answer from that. And there's much less of this kind of free-form, all things considered analysis of different kinds of competing interests. And so I want to say there's a justification for that and a defense of that, and actually I think there's a defense and a justification of that that has some resonances from within the Catholic tradition itself. So again, I can't do justice to all the metes and bounds of this. Let me just mention a couple of cases that illustrate this. Mark mentioned a bit about NIFLA versus Becerra already, and I won't rehash all that, although I will say a brief word about it. But I want to go back a couple years also to another case, Reed versus Town of Gilbert, which involved a challenge by a church, the Good News Community Church in a town in Arizona, that was led by a pastor named Clyde Reed. Now, the church, as it turns out, is poor, and so it doesn't have a building of its own. And so instead, the church would meet in public schools or basically any location they could find on a week-by-week basis, and often they didn't meet at the same place from week to week. So the town, as basically every municipality, I think, has a code that regulates signs and where signs can be and what kinds of signs you can have. And of course, most signs, like billboards, for example, require a permit. But there were three kinds of signs in the town's sign code that were exempted from that requirement. Anyone could put up such a sign without a permit, subject to certain restrictions. One category of exempt signs were ideological signs, simply expressing some idea, and those could be up to 20 feet in area and could go up without any time limit. A second category of exempt signs were political signs, like you see all over right now, wherever you're from. And those signs could be up to 16 square feet on residential property and up to 32 square feet anywhere else. And they had a time limit on them. They could only be up 60 days before a primary election and for 15 days following a general election. And finally, the third category of exempt signs for this purpose were temporary directional signs relating to a qualified event, which is basically any meeting of an assembly or nonprofit organization for religious, community services, educational, or other kinds of purposes. Those signs could be no more than 6 square feet, so much smaller than other kinds of signs, and they could only be displayed for 12 hours before the event and 1 hour after. So, as you might expect, the church got into trouble with the town's sign code enforcement authorities. The sign enforcement authorities said that a few times they'd put up the sign too early, they'd gotten a lot of trouble for keeping up the sign too late, and so forth. And so in a decision, there's actually unanimous as to the judgment, although divided somewhat as to the reasoning. Justice Thomas, who importantly later is the author of the court's decision in the California crisis pregnancy decision case, says that this is a case in which the court is confronting, as he puts it, a content-based regulation of speech, that these signs, regardless of the government's purpose, it doesn't necessarily mean that the government is targeting churches for any kind of disfavored treatment, but simply the facial, in this case literally facial, discrimination based on the kind of sign it is, an ideological sign, a political sign, or a sign giving directions to a community services or religious type event. The very fact that the government's discriminating on that basis triggers, as we call it in the law, strict scrutiny, which basically means that the kind of requirement is presumptively unconstitutional. As Justice Thomas put it memorably in the opinion, if a sign informs its reader of the time and place of a book club that will discuss John Locke's 2 treatises of government, that sign will be treated differently from a sign expressing the view that one should vote for one of Locke's followers in an upcoming election, and both signs will be treated differently from a sign expressing an ideological view rooted in Locke's theory of government. As he put it, more to the point, the church's signs inviting people to attend its worship services are treated differently from signs conveying other types of ideas. So that was the case in Reed versus Town of Gilbert, which was a powerful vindication of this categorical approach to content-based restrictions on speech. That again, there wouldn't be a lot of inquiry into the government's motive, there wouldn't be a kind of all things considered deference to the town's interest in regulation for beautification and safety, as the court has some points that it makes about that. And so the cases, at least in the majority's view, quite easily resolved as this kind of content-based restriction on speech. So also in NIFLA versus Becerra then this summer, not surprisingly authored by the same member of the Supreme Court, Justice Thomas, that the California crisis pregnancy disclosure requirement, which, and we're happy to talk more about NIFLA versus Becerra, which I think is an interesting case, especially for this conference, but the California, as Mark mentioned briefly, basically had 2 kinds of requirements. One for crisis pregnancy centers that perform medical procedures, and those, like ultrasounds, pregnancy tests, and so forth. And those centers were required to post information about the availability of low-cost abortion services and to post a telephone number for the county health agency that would connect women with abortion providers. And then a second set of requirements involving centers that did not perform medical procedures and weren't licensed to do so by the state, but were nonetheless required to post a notice that they were unlicensed to perform medical procedures, basically a quite prominent large type sign in multiple languages depending on the state's regulation that informed women that this center did not perform medical procedures. And so once again, you can see how this turns out. The court says this kind of requirement is content-based. It falls into this content-based categorical formula, and therefore, as a result of that, it was held to be unconstitutional. And the dissents, there's one dissent in Nifla versus Becerra, as Mark mentioned, not only, well, I guess they didn't use the weaponization language there. Oh, they did use the weaponization language there, but they also, there is a strong tenor in Justice Breyer's dissent in Nifla versus Becerra about how the state has all these interests in economic and safety regulation, and that actually in a concurrence in Reed versus Gilbert, he had made a similar kind of point that basically we shouldn't rest too easily with these formal categories, that instead we should have a more approach that took seriously the state's multiple interests that it might have in economic and safety regulation and so forth. And so you see there, again, a kind of a difference between the kind of categorizers and their opponents on the Supreme Court. And so, and again, we can talk more about implications for other kinds of abortion-related speech flowing from Nifla versus Becerra. There's been a lot of debate, of course, about whether or not the existing requirements in many states that abortion providers actually disclose information about the facts about abortion or the risks of abortion can be reconciled with the majority opinion in Nifla versus Becerra, which I think there are good arguments for that. But you see the point I want to make about how the approach that the court has taken here is one that is, as I say, somewhat categorical. So what is, to come back to my sort of introductory point and where I want to take this, this whole argument, what is the Catholic kind of argument about free speech? What might it say about this move from more kind of all things considered balancing judgments to something that is a little more categorical as a way of protecting the rights of freedom of speech? Well, in a little-known talk delivered in 1953 in the Philippines, John Courtney Murray, the great American Jesuit, most famous, of course, for his arguments about religious freedom, but he did actually write four to six, depending on how you count, essays addressing also the freedom of speech. He addressed the question of freedom of speech and the way in which a Catholic understanding of politics might try to approach free speech questions. Murray, who of course now I think, I'm sort of one of the last few robust defenders. Well, I guess to some extent Rick is too, but I think that Murray is sometimes, there's a kind of cartoon version of him as a apologist for American sort of liberal constitutionalism, which I think doesn't do justice to some of the range of his writings and some of his cultural criticism, for want of a better term. But at that time, Murray was actually quite critical in the 1940s and 50s of some of the then nascent developing Supreme Court case law, both on the Establishment Clause in the First Amendment, but also with regard to freedom of speech. He argues in this talk in the Philippines that there's this developing, as he put it, a kind of relativism and pragmatism that the Supreme Court is relying on, and that need not be the only way to think about why freedom of speech might be valuable and why it might be protected as a matter of American constitutional law, but because he was giving this address as part of, I gather, a kind of celebration of the Philippine Constitution as also a reflection of constitutionalism in a more general way. As he puts it, no philosophical doctrine about the nature of truth lay behind this restriction on governmental power. Rather, Murray puts it, the First Amendment reflects a purely political judgment resting on a sharp distinction between the state and society, between, as he says, the voluntary and coercive aspects of social existence, the voluntary being civil society, the coercive aspects being the state and government. Furthermore, and of course this is a familiar point from various places in Murray's writings, the state is subordinate to society. The government and its laws are instrumental to the common good of the social order. As he puts it, government was to have no power of deciding between conflicting beliefs and no function of protecting the teaching of one rather than of another. Its sole functions were to be, first, the protection of individual and social freedom to seek the truth and teach it, and secondly, the protection of public order, including an order of minimal public morality against abuses of freedom. And a bit later, in an essay that was republished in We Hold These Truths about censorship, he makes what are, to my view, some trenchant observations about the limits and aspirations of law. As he says, the aspirations of law are minimal. Law seeks only to establish and maintain that minimum of actualized morality that is necessary for the healthy functioning of the social order. It does not look to what is morally desirable or attempt to remove every moral taint from the atmosphere of society. And so, in Murray's view, which I think is a valuable corrective to many currents of free speech doctrine today, free speech is there to protect the institutions of civil society. It need not be based on a morally agnostic marketplace of ideas or a kind of Emersonian individualized self-expression, which you see in a lot of the literature on freedom of speech. And so, interestingly, these cases I mentioned as paradigm examples of this move to content-based categorical analysis and freedom of speech involved institutions of civil society. A church that sought to meet in different places around a town and was getting somewhat harassed by the government to advertise where its meetings were, and pro-life crisis pregnancy centers in California who were being, in the court's view, compelled to, in one case, advertise for abortion services, and another were being basically required to post, in the majority's view, an unnecessary disclosure about their provision of medical services. And so I think that these cases illustrate how a jurisprudential set of rules and categories can carry out this task of fostering civil society through the enforcement of the First Amendment's free speech guarantee. In doing so, the court is crafting a practically reasonable line focused on content-based regulation of speech. This is another point that Murray adverts to several times in these essays he wrote on freedom of speech, that in the end, the jurisprudential questions are left to kind of determination of practical reasonableness, and content-based restrictions might, take you a certain distance. There might be other categories that would be useful as well. But at bottom, we shouldn't think that there needs to be some kind of grand unified theory to explain all this. But the content-based regulation of speech analysis, I think, carries us quite a ways with regard to a wide range of cases. So at the end of the end of a Catholic defense, not the Catholic defense, but at least one of free speech, isn't such a grand unified theory or an all-purposes foundation to resolve the meaning of every First Amendment case, but instead a chastened view about what the law is and what it can do, and the vastly more important role of the institutions of civil society, including the church itself. Thank you.
That's great. Thanks very much to both of you. We have time for questions, and just raise your hand. I'll recognize you, and our colleagues here have a mic that they can speak into when they're answering. Floor's open. Or I can be that obnoxious law professor and just start calling on people. Yes, go ahead.
I'm Grady Stuckman. I'd first like to thank you for your talk, and both of you. My question is directed to Dr. Moreland. I was at the talk on medical morality and bioethics this morning. I'm curious, Dr. Moreland, as to know what you think the future of conscientious objectors, in hospitals and other medical institutions will be.
Great.
Well, of course, it's a much contested question right now. Niffle versus Becerra is just one dimension of it. And as I also mentioned, there's a discussion in the case in both the majority and the dissent about whether or not there can be compelled disclosures in the context of performing abortions, in addition to now under NIFLA, the refusal of some institutions to post these advertisements and so forth. But as your question suggests, a lot of the action is around the question of whether or not Catholic hospitals, for the most part we're talking about, can be required to, say, offer abortion services or other kinds of morally objectionable procedures. With regard to, and I'm just kind of describing some facets of the problem. I think, you know, we're going to see a lot of state-by-state litigation about this, and we already have. With regard to abortion, there is already in place a fairly robust federal statutory set of protections for objecting institutions and individual providers. The question is, of course, how will that, it's not even consensus, but will that fact of the statutory protections for, in that context prevail? And also, to what extent will some of the ACLU, for example, has filed suit in some cases, thus far mostly unsuccessfully, to, for example, object to Catholic hospitals' refusal to perform abortions in certain kinds of cases. And I just don't know. I mean, I think in some ways this is a question that Professor DiGirolamo could answer just as well, because I think a lot of it depends on whether the ambient culture around individualized or institutional conscience protection becomes one that is continues to have some solicitude, or will there be more and more effort to quash dissent?
Yeah.
Hi, Grant Scrope, Learning Law School. My question for the panel has specifically to do with non-discrimination clauses that a lot of public colleges and universities are forcing student groups, religious student groups in particular, to abide by, that limits their ability to choose the leadership of their groups and the activities of the groups. What are your thoughts on the future of such non-discrimination clauses, especially post-CLS versus Martinez?
Yeah, well, as you mentioned, the critical case is CLS versus Martinez. That's a little bit of a complicated case in as much as the non-discrimination policy at issue there was interpreted and was stipulated by all parties to reflect what was called an all-comers interpretation, which has always seemed to me to be crazy, that is to say that all groups are required to accept all comers with respect to all positions of leadership. It's sort of like, the more inclusivity and diversity you get to a state where there's so much inclusivity and diversity that there's no inclusivity or diversity. And so that is, it seems to me, a problematic case. Now there have been other decisions in the circuits. There's a case out of the Seventh Circuit, actually, CLS versus Walker, authored by Judge Sykes, where the record was rather different. Now it seems to me there's some conclusions that Judge Sykes reaches in that decision that are at least qualified, if not injured, by CLS versus Martinez, but it's not clear to me. I'm not certain about this, but it's not clear to me that that CLS Martinez is the sort of death knell for these kinds of groups with respect to these sorts of dealing with a non-discrimination provision. But I do think that a clever university, a clever law school, is going to be able to have its way with these groups, and so it will be as much a matter of prudential and wise leadership in these institutions, the quote-unquote institutions of civil society, as it is a matter of law. That's what I would say. Mike?
Just add one quick thing to that. It's worth remembering, of course, that we have state-run government institutions of higher ed, and then we have a whole swath of non-state institutions. And, generally speaking, the private schools operate in kind of a First Amendment free zone. So whatever happens at state institutions like Hastings Law School in the Martinez case, or at the University of Michigan, we should certainly expect to see lots of private institutions, including some of our very best ones, being pretty aggressive with these non-discrimination rules. I mean, Harvard University recently adopted a policy where the university is punishing students who are involved in single-sex organizations like fraternities and sororities and so on. So we'll see more of that, I think. Anyway, another question? Yeah.
Just curious, appreciate your remarks on the term weaponization. How would you describe the current trajectory of this term hate speech? Have the courts addressed it, defined it? Is it moving up that we might start to see that in higher court decisions, that term?
The question is a good one. To date, of course, hate speech has been described by a majority of the court as fully protected. One of the cases that Michael mentioned this past term, I reaffirmed just that. I think it's either Mattal versus Tam, which is a case from last term, or the case, the Mansky case from Minnesota. But the court has come out, at least a majority of the court has come out fairly strongly recently, reaffirming the position that hate speech as such is fully protected. Now, there are other wrinkles here when we're talking about, for example, hate crime, crimes that are motivated by some sort of hateful purpose. Those have been upheld for different sorts of reasons that involve the special justifications for preying on certain sorts of constituents that are weak or defenseless and so on. So I think, at least for the moment and with respect to the present court, reading tea leaves is often difficult. But I think that hate speech, at least as such, if defined as such, if you've got a law that bans hate speech, will probably be protected. Now, whether in lower courts, for example, for something narrower, some sort of narrower regulation that is essentially targeting a kind of hate speech, whether those are able to be recharacterized as acts of violence or somehow different sorts of impositions that somehow go beyond the content of the speech, I think that's probably more likely. And remember, the Supreme Court only reviews a very, very small number of cases, so it's not like they go systematically and they review every single hate speech disposition in the lower courts. There's a lot of law that gets made that is not Supreme Court law.
With respect to this point about the Supreme Court only taking a few cases, there's a great old story about kind of a small town country judge. The story says Tennessee, but it doesn't matter where he was. And a lawyer comes up to him and says, "Hey, Judge, did you hear that the Supreme Court overruled you in one of your cases from a few years ago?" And he shrugged his shoulders and said, "That's okay, I overrule them every day."
Hi, this is Father Georgi from Rome. I have a question that it's not, it's a broader question on the internet. I would like to ask you, free speech, the free speech liberal tradition that has been fought for paper, TV and the mainstream media. What happens in the internet? I mean, we have these guys, technological companies, saying that they are moderating the conversation under the rule, my house, my rules, but they are moderating the conversation of 2 billion people. So if that is not public interest. So my question would be, do you see any change there in the, I know it's not an American, it's a question of a worldwide thing, but the traditions in Europe and in America are very different. But do you see any, because if these guys are moderating the conversation and their interests are commercial, I see that, I think that's a problem for the public conversation. And I would like, your opinions on that also risks.
At least in the United States, we have a very strong commitment to a kind of public-private distinction, which is rooted in the liberal tradition, I think, pretty deeply. And so I acknowledge, and I see these stories come out about Facebook censoring ads or managing content, Twitter doing the same thing. And every once in a while you'll hear arguments, and sometimes it cross-cuts ideological boundaries actually. People will say, well, there should be more government regulation of them. Some people say they should be treated as almost like a public utility because they're providing so much informational content. Google, of course, is a big player in this space as well. And I guess I come at it, my priors are so agnostic about, or not antagonistic about kind of government regulation of private actors in that way, and that the better approach, so here I will go to the marketplace of ideas, is that better to allow competitors in the media space to emerge as an alternative rather than have the state come in and try to manage them as public utilities or something like that, because it seems to me that then we just sort of, you know, move over sort of where the regulation is happening, and that I think public choice and other kinds of accounts would say that never ends satisfactorily.
Yeah, I think I probably agree with what Mike just said. Two things that are interesting about this particular area. The first is, you know, I mentioned the sort of the efforts toward constriction, towards First Amendment constriction, but I think that could be, you could say something broader about efforts towards speech constriction more broadly. And I think that the people who are interested in moderation and in bridging the public-private distinction are some of the same people that are experiencing the same sorts of anxieties about what all of this speech is doing to us. That all of this speech is harmful, that it's bad. And that leads me to think about one of the cardinal justifications about speech, that more speech, one of these sort of central liberal ideas, more speech means more truth, right? The more speech we get, the more access to truth we get. I think social media is putting a certain degree of pressure on that idea. Is it really true? First, there's a kind of self-defeating quality about the justifications of free speech in this respect, that more speech leads us to more truth. More speech leads us, but of course there is no truth. There's only what people say on social media, and our commitment is to having everybody say whatever they want to say, and that will lead us to the truth. But nothing that anybody ever says actually is the truth. It just leads to the next thing that will be the truth, and the next thing, and the more, right? So at a certain point, the idea that we're actually cultivating a certain set of ideas about the truth falls out, and what we're left with is noise.
I agree. I don't have anything useful to add to that. I think it's well said. I mean, the social media and the internet and the tech revolution generally, they remind us of something that's worth keeping in mind. They remind us that although the public-private distinction is important, that coercive power, dangerous coercive power, can be and is wielded by private entities all the time. Patrick Deneen has sounded this theme in First Things magazine recently quite a bit, just pointing out the extent to which many of the kind of culture-shaping actions that a lot of Christians and traditionalists would worry about are actually coming from big corporations rather than from the government. So we need to remember that. We do need to remember, as Mark just said, that the marketplace of ideas, Holmes's image is a catchy one, but it's probably not empirically borne out that more speech actually yields more truth. That's worth remembering too. And yet, at the end of the day, for reasons like Michael's, I come down on the side that says counter-speech is likely to be preferable, competition is likely to be preferable to government regulation in this area. Yes, ma'am?
I think, not that I think that regulation is the key here, but I think pornography is one area where we see there is no competing free speech to pornography, and there's a lot of research that shows that the brains of young men have been absolutely changed by viewing pornography at very young ages. We're talking 8, 9 years old because of their access through the internet, and that they're being rewired so that they respond only to what people traditionally would call abnormal situations, that they cannot respond to a more innocent encounter with a real young woman. And I just think there's a physiological component, you can look, there's lots of research about this now. That the brains of young men are different now because of having viewed this kind of stuff for 5 or more years before they're even fully adolescent. And I think that we do have to keep that kind of thing in mind. I mean, I think the basic thing is, as parents, we have to make sure that our kids don't have access to this when they're very young. I don't think there is a government role that it would be actually effective. But also it is the fastest growing form of addiction. Faster even than internet gambling, which has exploded, of course.
You guys want to speak to that?
So I'll just say something quickly, and that is, this is a point where perhaps I might differ slightly from some of my esteemed and dear friends here, that it wasn't always so that we just didn't trust the government to get involved in these issues. It wasn't always so. In the early republic, we did trust. In fact, we gave a large ambit to our legislature to make judgments about what was in the public interest in this way. And many of the sorts of restrictions that they made involved issues of what were commonly regarded as matters of public morality. Along the way, we have used the First Amendment. The First Amendment was consistently and very effectively used to strike down a lot of that kind of regulation as unconstitutional in the name of neutrality, in the name of content neutrality. Whether it actually fostered content neutrality or something else is, I think, something that we need to think about.
You brought to mind, my uncle was an appellate judge in Missouri in the late 60s, early 70s. He was, or this might have been when he was a federal prosecutor. He was asked to watch the film I Am Curious Yellow. I don't know if there's anybody else old enough here to remember that. But I asked him about it, and I mean, he was asked to judge whether this was pornography or not at the time, and he said it was just boring. And I think that's some of the danger is that this stuff becomes so banal and so boring that we just accept that as normal everyday stuff. I know that there are many shows on Netflix or Amazon, which I don't watch any of that stuff, but that would be shocking to people only 30 years ago.
I appreciate the question because I acknowledge that my defense of, I guess, a kind of semi-libertarian view of free speech, benignly recounts protecting, storefront churches and crisis pregnancy centers, and that these cases involving pornography are much more difficult. I mean, a more extended version of what I was trying to say would point out that in the violent video games case, for example, which was another case where the court struck down a speech restriction using content-based analysis, that if there's any opinion in the last 10 or 15 years after this became kind of the focal way of addressing these cases, if there's any case that, in my view, might have been a little, I'm not going to say it's wrong, but it's a little overwritten in the way in which Justice Scalia resolved that case, and in particular the way in which there was a cavalier dismissal, I don't want to be too harsh, but a somewhat cavalier dismissal of the state's interest in facilitating the ability of parents and families to control what minors had access to, because the California regulation restricted minors from buying these violent video games without an adult with them. And that ties in to some of what Murray says also, because Murray does talk quite frankly about public morality and public order and the institutions of civil society as a kind of unified way of thinking about free speech questions. The problem is a familiar one to people who work in this area, of course, is a lot of issues about line drawing and so forth. But I guess that's all by way of saying that I acknowledge the import of the question.
We have time for one more.
Would you mind just elaborating on the point about the early days of the Republic where legislatures did address issues of public morality like this?
Sure. And this is, I'm happy to share my paper. You didn't ask, but I'll offer. But I do think that during the early republic, if one were to consider the scope of, there they are, they had the freedom of speech in the early republic. But what did it encompass? Well, what it encompassed was thought to be situated within a larger view about the scope and limits of natural rights. Natural rights, just to sort of foreshorten the discussion when it came to speech, were thought to be especially powerful when it came to the good faith expression of one's views on any particular public question. With respect to other sorts of, just as an example, you could go out onto the street corner and explain to people why, Governor Winthrop ought not to be elected. But if you went out onto the street corner and started screaming obscenities and, started saying, all kinds of blasphemous things about Governor Winthrop, that was not going to be thought to be encompassed by the freedom of speech. Now, I want to be clear about something. I'm not saying, and therefore, we need to adopt similar sorts of views today, right? We need to outlaw blasphemy. What I'm saying is, there's a difference between the line drawing question and the question whether, in principle, there are any lines to be drawn. Those are two separate analytical questions. And in the early republic, it was never thought that the state has no proper role in drawing any lines. It may be that our lines are the same or different, but the idea that there are no lines to be drawn, that it is improper for the state to make substantive judgments about the value of speech, seems to me to be a modern development. And it is one that I think has deleterious effects on our social institutions themselves. That's sort of the short version, but I'm delighted to smother you with a long version.
Please join me in thanking both of our panelists.